Good morning, everyone. Thanks for joining us for the ABC Michigan webinar on earned sick time. Probably the most popular topic in Michigan right now, not for great reasons for small business owners. Um, I am Shane Hernandez. If you don't know me, I'm the president of ABC of Michigan. This is probably the largest group I've seen for a webinar that we've had. So I'm actually going to give Eric Chappelle a chance to say hello and introduce himself as well. He is our director of legislative affairs at ABC of Michigan. Eric.
Yeah, thanks, Shane, for all of those that don't know me or haven't met me yet. Eric Chappelle joined the team at the end of August of this year, so it was about coming up on 5 months being with ABC, and it's been quite a ride getting through the election and surviving lame duck, but we're excited for the term ahead. I previously worked for the House of Representatives for about 7 years, worked for a couple of state reps, and then most recently as a policy advisor for the House Republicans. So excited to be a part of the team. You know, it's Shane and I fighting for you in Lansing, and we look forward to a good term ahead. So look
All
forward to
right.
meeting all of you.
Thanks, Eric. Eric and I are we're your legislative and policy team in Lansing, staying on top of all of the issues for you guys and hoping that this coming term is a lot easier to stay on top of things. We are obviously still dealing with the fallout of earned sick time, which was a ballot initiative that passed. There was a lot of hope that the legislature would actually make some changes to it before the end of the term so that this would not go into effect. At this point, while the new legislature is working on this, I want to emphasize the importance of all of you planning for this to go into effect. Even if the legislature does manage to change this, it's going to go in effect before they change it. So be prepared for that. I am going to drop a file in the chat for you guys. Um, I would say feel free to share this within your company, but please don't post this on social media or share it outside of ABC membership. This is a file that compares the Senate bills to fix earned sick time, the House bills that fix earned sick time, with the law that will soon take effect. I just don't want it posted out on publicly on social media, but you can share it within your company with whoever you would like. It's a good comparison. What you will see in that is that the Senate fix isn't much of a fix. The House fix is really where we are going to put our efforts. Eric and I were monitoring committees this week, and we did put in cards of support saying that ABC of Michigan supports these changes. Um, the House committee met for a significant amount of time on Tuesday um, and yesterday, I guess. They voted 4002 and 4001, which deals with minimum wage and paid and the tip credit. They voted them out of committee. Um, 4002, which is what we're talking about today, was a unanimous vote out of committee. So that's promising and hopeful. Every Democrat and every Republican on the committee voted for the bills. Um, they will go to the House floor next week. I do expect the House to try to vote on these next week, and I would expect them to be bipartisan. I would not get your hopes up necessarily too much about that. I think it's a great step. I think it's exciting to see it start to move. But the Senate is really where this fight's going to be. The Senate bill is significantly different than the House bill. The Senate leader was really one of the reasons that this didn't happen last term at the end of the year. And I think the Senate leader is going to come to the negotiation table asking for a lot in exchange for allowing this to pass. I think the votes are there to pass it in the Senate, but it's up to the leader whether or not that this will go on the board to be passed. So uh, there's going to be a negotiation. There's going to be the House, the governor, which I'm hopeful. The governor has not made a ton of comments on this, and I think that's a good thing that the governor is not making a ton of comments on this and keeping the door open. The Senate is kind of put their stake in the ground with their bill. So we'll see where that conversation goes. I'm hopeful that they will come to a solution. The question is when and what does it look like? I do see the question in the chat about what do we recommend an employer does if this gets changed a week after the implementation. I will leave that to Jeff to kind of talk about how to handle that as an employer if this implements and then the change comes later. Just general process for lawmaking in the legislature. This has to pass the House. The identical bill has to pass the Senate, and the governor has to sign it. So when the House passes it, it has to lie over in the Senate for 5 days. If the Senate amends it before they vote on it, it has to come back to the House to be voted on again until they agree on the identical bill. And then the governor has 14 days to sign it, assuming that the Senate gets what is called immediate effect, which requires a two-thirds vote, not a 50% vote. If it gets immediate effect, the law would go into effect 90 days after the vote. If it doesn't get immediate effect, the law would not go into effect until 90 days after the last session day of this year. So that can, like, let's just say that they get this done in 2 weeks. You still have 90 days after that if everything went great. If everything doesn't go great, you could have 90 days after the end of the year, or if it goes very poorly, they never come to an agreement and this doesn't happen. So that's just kind of setting the expectation for you guys at this point. Um, I'm going to hand it over to Jeff. We will allow questions afterward on either the process in the legislature or on the law itself, how to plan for it. The question that's already in the chat, you're welcome to put questions in the chat. And we will have an opportunity also for you to just raise your hand and come off a mute and ask a question as well. We are recording this just so everybody's aware. But with that, I'm going to hand this over to Jeff Theuer from Foster Swift to run through what to expect.
Okay, thanks, Shane, and good morning, everyone. Thanks for being here. This is kind of the further roller coaster ride of what's going to happen with the Sick Leave Act after years in the courts. And here we are a month from implementation, and we're still not sure what it's going to look like. So, what I'm going to focus on today, because all of you sort of need to understand that regardless of what comes out of the legislature now, they have been working around the margins of this act. It's not going to go away completely. There are certain things that are going to change, but you're still going to have to be ready for it. So we'll go over today what the current status of the act is. I'll try to point out those areas that may get influenced or changed through the legislation that's currently being pushed through. But again, we don't know what that's going to look like in the end. It's probably going to require a lot of compromise, and there's going to be some things that get in and some things that don't. So we're going to focus on what we have to do now, and then we'll talk about maybe what might change in the future. So let me give you just a couple words about myself before we start. For those that don't know me, my name is Jeff Theuer. I have been involved with ABC for about 30 years. I was the chapter attorney for the Central Michigan chapter when there was a Central Michigan chapter. Served on that board on and off for 6 or 7 years. And I have been helping ABC Michigan with various legislative, governance, and litigation matters ever since. Very happy to be associated with ABC, and I'm happy to do this for you guys today. So with that said, let me see if I can share my screen here. Okay, and I will push it out. Okay, can everybody see that? Okay, so let me get the first thing out of the way first. This is my contact information. If you have questions, feel free to email me. I'm more than happy to respond to any questions. This is a quick moving thing. It almost goes from day to day, minute to minute. So it's certainly confusing. Um, my firm requires that I provide this little disclaimer at the beginning, of course. This is a generalized discussion of what's going on right now with this act. It doesn't apply to your specific situation. Facts do matter in a lot of these cases, so just be aware of that. If you have a specific situation that you need analyzed, you should go see your own attorney, or you can email me or contact me. Happy to help. Okay, so let's talk about who is covered first by this act. As you all know, it becomes effective February 21st of this year, and it covers all Michigan employers with one or more employees, except for employees of the United States government, and there's certain rail workers that are exempt as well, but those are going to be marginal. So basically, it covers everyone. It also includes salaried employees, both exempt and non-exempt. And they are presumed, for purposes of the calculation that we're going to go over in a minute, to work 40 hours per week. It also includes full and part-time employees. So there's an interesting issue with respect to non-Michigan employees here. The ESTA is going to apply to work that is performed by employees in Michigan, not outside of Michigan. So you need to keep track of that if you send crews out to Ohio or Indiana. And the employer's location doesn't matter. In other words, if your company is based in Chicago, but you run a crew of 5 guys into Michigan, those 5 guys are going to be covered, and they have to be provided the benefits under the ESTA. Not the rest of your employees, just the 5 that you ran into Michigan. Okay, so the nuts and bolts of this are how the sick time is calculated. Sick time accrues at a rate of 1 hour for every 30 hours worked. And then there are differences between how small businesses have to accrue that time and how large businesses have to accrue that time. So I'm going to split those out. As you'll see as we move along here, it's difficult, unless you're a truly small business, it's difficult to maintain that status as a small business. It's based on having 10 employees, essentially, is the critical number, and we'll get into that right now. So a small business under the Act is considered someone that has 9 or less employees. So you have to have less than 10 employees, but if you get that 10th employee, as we'll talk about it in a little bit more detail, then you become a large employer. So this only applies to the small 9 or less employees. They have to allow the accrual of sick time up to 40 paid sick hours, 40 hours of paid sick time per year, plus an additional 32 hours of unpaid sick time. You have to bank those separately because the employee is allowed to use the paid sick time first. It's their option, not yours as the employer. You can, as an employer, select a higher limit. So in other words, under the small business rule, you got 72 total hours, 40 paid, 32 unpaid. If your employee handbook or some policy that you have offers 90 hours or something like that, you can do that. This establishes just a minimum sort of floor. So you can go above that if you want to, but you have to meet at least this. Okay, so what is a small business? Let's see here. Make sure I'm going the right way. Okay, this is a little bit technical, and this is where it gets kind of difficult to manage, because a small business is one that employs 9 or fewer individuals, or you can employ more than that as long as you don't do so for more than 20 work weeks within any current year or a prior year. The work weeks don't have to be consecutive, so you could start in January and you might have some more in July and more in October. As soon as you hit that 20-week number with 10 employees, then you're a large employer. So again, there's kind of a built-in incentive never to hire that 10th employee under this act. That includes full-time, part-time, and temporary workers. It also includes workers that you might get through a temp service or a staffing agency. And it includes all employees within the US. So this is a kind of an inconsistency with what we talked about earlier, because if you are if you're a Chicago-based company, for example, and you have 300 total employees, but you only run 5 guys into Michigan, you're still a large business because all of your employees together are 305, and that makes you a large business. So be aware of that. Okay, large businesses are employers with 10 or more employees, and they have to allow the accrual of up to 72 hours of paid sick time to accrue per year. So again, that's the difference between small and large is large businesses have to offer 72 accrued hours of paid sick time. Small businesses are 40 hours of paid, 32 of unpaid. And again, an employer can offer a larger limit if they want to. And we've discussed this a little bit, but what is a large business? It's a business that employs 10 or more employees for 20 or more work weeks in the prior or a calendar year. Now, this is important because if you're a small business and you hire 10 people, then even if you wind up laying off a bunch of people and you go back down to 5, you are still a large business for the next year because you qualified in the first year. So this trails for a year once you qualify as a large business. Again, the work weeks don't have to be consecutive in this calculation. It includes everyone, full-time, part-time, temporary, temp service and staffing agency hires, and all employees within the US for your business. So this leads to a problem that has not been resolved yet and isn't really proposed to be resolved under the current bills that are going through. And that's what happens to the accrued hours if you're a small employer and you become a large employer. So the example here is if you're a small employer, you got 9 employees, you add that 10th employee early in the year, and you go for 20 weeks with that employee, so you've got 10, you qualify as a large. What happens to the employees that have accrued unpaid leave during the period before you became a large employer? You have to keep track of all this stuff. You have to maintain an accounting of how many hours have been accrued for the sick time. Are those hours converted to paid hours when you become large? It's not clear. There's no guidance from Leo on this, no guidance from the wage hour division, and the statute really doesn't address it either. It's probably going to get addressed through some kind of guidance after the statute becomes finalized, but again, that may be months down the road. And just to go back for a moment, the safest thing would be to just assume that it's all paid once you become a large employer. That way, there's no way to be second guessed. But again, you're on the hook for 32 hours of paid sick leave. Okay, so let's talk about carryover. This is one of the things that is being actively discussed in the proposed revisions to this thing. Currently, accrual begins on February 21st. So every hour worked on February 1st, 2025 starts this 1 hour per 30 hours worked timer. Currently, all unused earned sick time carries over from year to year. That means that you can, in theory, have a bank after a few years, if this thing is still out there, you could have a bank of unused earned sick time in the hundreds or even thousands of hours. You have to keep track of all that so that you know how many hours your employees have, but they don't get to use it all. They can only use 72 within any 12-month period. So in other words, even if they have 1,000 sick hours out there, they can only use under the ESTA 72 in any 12-month period. And the bank continues to sit out there. If you've got long-term employees, they're undoubtedly going to have huge banks after a few years with this. But again, you don't have to let them use it. They can only use 72. If you're a small employer, they can only use 40 paid, 32 unpaid. Large employers have to allow 72 paid. So what happens if an employee is separated from their employment? Employees separated from their employment for 6 months or less maintain their bank. So if you lay somebody off, maybe you're going to bring them back, maybe you're not. You need to make sure that you keep that accounting, and we'll talk about record keeping later. It's actually longer than that, but it's sort of a top of mind thing to keep that bank for that employee for 6 months. Because if they come back in 6 months or less, they don't start over. They pick up with their accrued time. So if they've got 40 hours accrued, when you lay them off, they come back 3 weeks later or 3 months later even, they still have those 40 hours moving forward, and they continue to accrue once they start working again. If you transfer an employee to a different job, to a different location in the same employer, then all the accrued hours come with them. They don't start over with a new position. They don't start over with a new location. It's not clear if you are a company that has subsidiaries and you transfer from one subsidiary to another. It is not clear what happens in that instance. There isn't any guidance from Leo yet on this. The statute doesn't really address it either. But again, the safest thing to do would be to continue their accrual if you have a subsidiary that's all controlled in the same sort of control group. But again, it's not completely addressed. If you terminate an employee, then they lose all their accrued earned sick time after 6 months. So you lay somebody off, 6 months later, they lose all their accrued sick time. If you rehire them we'll say 7 or 8 months later, bring them back, they've lost their accrued time. They have to start over from zero. Okay, so let's talk about front loading and payment. This is again an issue that is being addressed now in these potential revisions, but Leo has actually offered guidance on this issue. So let's go over what currently exists. According to Leo's interpretation of the statute, because it's not addressed in the statute and it's not prohibited in the statute, they are currently taking the position that the total amount of hours can be provided at the beginning of the year. So you can front load by crediting your employees with 72 hours at the beginning of the calendar year or whatever 12-month period you're using, because you don't have to use a calendar year if you want. But you can do that. And you can also, according to Leo again, recoup the value of any unearned sick time if they leave your employment before they've actually earned the amount that they've already taken. So if you front load 72 hours and a month in, the employee takes those 72 hours and then quits the next month, they haven't earned all those 72 hours probably from the accrual. You are entitled to get that back, but it's a little complicated because if you want to get it back out of their last check, for example, you have to have a written voluntary agreement. So you should look at your handbooks and any policies that you have to see if you are authorized to make a wage deduction. They would have to sign that wage deduction in order for that to be effective. It's a little dangerous outside of that. But if you front load, you may want, and you don't have that voluntary agreement to withhold from the last paycheck, then you may be out that money by front loading. The other thing about accrual is you're allowed to disallow an employee from taking paid sick leave until 90 calendar days after they start employment. That doesn't count for someone who's laid off and then comes back with an accrued bank. But if you have a new employee, they start accrual right when they're hired, assuming it's after February 21st. But you can, as a policy matter, decide that they can't take any of that leave for 90 days. But it continues to accrue, so you have to, again, their bank is their bank, but you can wait for 90 days to allow them to take it. The key provision here is that there is no obligation to pay accrued hours on termination. That is an absolutely critical thing in here because, again, you can wind up with an accrued sick time bank of hundreds, thousands of hours after a few years. But again, if you terminate an employee or they leave or whatever, there is no obligation to pay those accrued hours unless you have made that part of your company policy. So again, check your handbooks, check your company policies, check your employment contracts. Make sure that you don't have an independent obligation to pay accrued sick hours because you don't want to get in trouble there because, again, this could be a large expense potentially. The act itself, however, does not provide an obligation to pay. And again, after 6 months, a separated employee loses their entire bank. So another question about payment is what increment it can be done in. This is, again, something that is being addressed in those revisions, and we'll see what happens to them. But the way the act currently reads is that sick time can be used in the smaller of 1 hour increments or the smallest increment that you use in your payroll system. So in other words, if you track being late to work in increments of 5 minutes, 15 minutes, then in theory, your employee could say, hey, I need 15 minutes of sick time to do something, whatever it might be, run to the pharmacy or something like that. It's got to be for an appropriate purpose. We'll get into that in a minute. But they could, in theory, take a much smaller sick leave increment. The revisions that are going through right now are contemplating making that 1 hour increments, which is more reasonable, but just be aware they don't have to take it in a day. They don't have to take it in a half day. It can be 1 hour. And the other issue that's come up in the guidance is if an employer wants to avoid the carryover obligation, some employers have asked whether they can just pay out the unused sick leave and not have the carryover. That's not authorized under the statute. And Leo has taken the position that an employer can't pay out unused earned sick leave in lieu of a carryover. So you're kind of stuck with the bank. You have to maintain it. You have to account for it. And, it's going to be there almost no matter what you do. But again, you can limit their use to 72 hours a year, regardless of how big it is. Okay, so what wage rate do you pay sick leave out at? It has to be paid out at the greater of the employee's regular pay rate or the Michigan minimum wage. So that might seem obvious, but there's a couple issues with that. One is if you have an employee that does several different jobs for you, and depending on their job, they get paid at a different rate of pay, then the normal hourly wage for purposes of paying sick time is the average hourly rate of the employee in the pay period prior to when the sick leave is used. So you average that hourly rate regardless of what jobs they were doing, whatever that hourly rate is in the pay period before they go on leave, that's the rate that they have to be paid at. One benefit from this is that fringe benefits don't count toward the normal hourly wage. We're just talking about the base hourly wage here. So then the question is, what about PTO? Many employers have moved to a PTO policy, and that provides leave for a lot of purposes, including sick leave. You can aggregate all of the obligations under the ESTA into your paid leave, into your PTO policy. But there's a trick to it. and that's that it has to provide at least the same benefits as the ESTA, and it has to be used for the same purposes. And if you have that kind of a PTO policy, then you don't have to create a separate bank for the accrual of the ESTA time. You can just use your PTO accrual rate, whatever that is. Now, that might seem straightforward initially because if you have a policy that provides 90 days of PTO, that's more than 72, so that would seem to do it. The problem is going to be the part about used for the same purposes. And we're going to get into the authorized purposes in just a minute here. But the trick is that there are specific things that ESTA leave can be used for. And if your PTO policy differs from those, then you may run into trouble. And this is going to be a situation where it'll depend on the facts of the situation, because if your PTO policy covers some of the purposes of the ESTA and your employee comes in, let's say it's a doctor's visit, which is covered under your PTO, it's covered under the ESTA. The employee comes in and says, I want to take 8 hours to go to a doctor's appointment on this day. That's not going to be a problem because it's authorized under your PTO and the ESTA. Where you run into trouble is going to be if the employee says, I want to take this leave and it's not authorized under your PTO policy, but it is under the ESTA. And in that situation, you're going to be better off letting them go anyway. But you might consider, assuming that the act goes through largely unchanged with respect to this issue, you might want to consider altering your internal policies, your handbook, so that the uses of PTO time match the uses of the ESTA. Okay, so let's talk about what those authorized reasons are. And I know there's a lot of words here. These are taken from the statute, essentially, but the critical issues here are you can use ESTA leave for an employee or an employee family's mental or physical illness, injury, or health condition. And almost anything that is related to that mental, physical illness, injury, or health condition is going to be an authorized use under the ESTA. It includes diagnosis, treatment, preventative care, just about anything. So it's very broad. You can also use ESTA in cases of domestic violence and sexual assault. And this is also really broad. It can be used for medical care, psychological, or counseling. It can also be used to obtain services from a victim services organization, even to relocate to another residence as a result of domestic violence or sexual assault, and to consult with lawyers or participate in criminal or civil proceedings related to that domestic violence or sexual assault. ESTA leave can also be used for meetings at a child's school or place of care if it relates to the child's health or disability or the effect of domestic violence and sexual assault. So in other words, if the teacher calls and says that the child has not turned in homework and they want to meet with you, that's not an authorized ESTA leave. But if the school calls and says the child is sick, then the employee can use their accrued ESTA sick leave in order to pick up the child, take them to a hospital or a doctor or whatever that might be. There's also this sort of interesting add-on here at the end of the section, which is if an employee's place of business is closed by an order of a public official due to a public health emergency, or a child's school is closed for the same reason, that can also be an ESTA use. As can if a doctor determined that an employee or a family member had a communicable disease and that their presence in the community would be detrimental, that is also an ESTA authorized use. So you can see these are pretty broad, and because they they contemplate things that may not have been contemplated in your PTO policy, for example. You may want to review if you're going to use PTO as your uh, as your above floor sick leave policy. You want to make sure that all of these reasons here are included in your PTO. Otherwise, you may get a request for PTO, for a reason that would comply with ESTA, and you're going to have to allow it, even if the person is over their PTO number, for example. So that's the complication. Okay, so you remember in the last slide we talked about an employee or employee's family member. So who is a family member? And again, this is an incredibly broad definition, as you might expect, given where this statute came from. So it includes just about any kid, stepchild, legal ward, including the children of a domestic partner, or any child who the employee stands in loco parentis. Now that's an odd legal term that isn't in use a lot very often anymore, but that means anyone who stands sort of in the same position as a parent with respect to a child, that child is considered a family member, even if they're not technically a child. So that can be like an aunt that is taking care of a child. That child is part of the family for ESTA purposes. It can be a neighbor who a child is left in the care of while the actual parents are away for some period of time. That can also make that child a family member of that neighbor, for example. So also included within the definition of family member are domestic partners. Domestic partners includes same-sex relationships. You're not going to be able to get away from that unless you want to challenge it for some reason, but that would again be a court case. And again, this is very broad, as you can see here. It includes grandparents, grandchildren, foster adopted siblings, even. And the other catch-all is any other person related by blood or affinity who is equivalent to a family relationship. So that's pretty broad because affinity means just anybody who is considered so close to you that they are, or to the employee, that they would consider them family. So it becomes a little difficult at some level. And again, if you have a problem with this in the interpretation of it with respect to a particular employee, you should probably consult an attorney if you want to contest that. Again, the safest route is just to allow them to take the leave. Again, they only got 72 hours per year. So regardless of who they use it on, whether it's someone who has affinity and is a family member that way, or whether it's an actual family member, it all comes out of the same 72-hour pot. So notice requirements. This is another issue that's become kind of controversial in the comments on the original draft of this act and in the revisions. So the employee has to provide notice under certain circumstances. If, for example, the earned sick time is foreseeable, there's an operation coming up, for example, and it's been scheduled, the employer may require up to 7 days of advance notice. Now, the question is, how do you implement that policy? It would be best if it were written down somewhere. If it were in your employee handbook, sometimes some employers do have that kind of thing in their handbooks already. If not, you can send out a written notice to everyone saying that if you're going to use ESTA leave, you have to give us 7 days advance notice if it's foreseeable. If it's not foreseeable, the employee must notify as soon as practicable. What that means is that the employee can basically not show up. And at some point, that is practicable, they have to tell you, hey, I'm taking ESTA leave. That's obviously clearly unfair, especially if you run a business where you have to dispatch people out to service customers and an employee is a no-show on a particular day. So this is again something that is trying to be worked out in the revision process. Hopefully it will be, but for now, it's not there. So if the employee gets sick, in theory, they don't have to provide notice until after 3 days. And that's the next bullet there. After 3 days, the employer can require reasonable documentation. There's rules on that that we'll go over in just a second. And the other caveat to that is that in order to get that reasonable documentation, the employer has to pay for it if it costs money to the employee. So if the employee has to go to their doctor to get a doctor's note after 3 days, and it cost them whatever amount it costs to get that doctor's note, then in theory that's chargeable against the employer. So just be aware of that. Then with respect to the notice itself, there are several issues, and these all relate to concerns about confidentiality for health conditions and just health information generally. So in other words, an employer can ask for reasonable documentation after 3 days. They can say, for example, we need a doctor's note that will verify that you are ill and are eligible for sick leave under the ESTA. The doctor's note and the employer cannot demand a description of the illness or the details of violence if it's a sexual assault or domestic violence. So all you can ask for are sort of categories of what the purpose of the leave is. So, the employee is ill, the employee had to go to court, the employee had to move due to domestic violence, but you can't ask for any detail beyond that. And the other thing about the current statute, and again, hopefully some of this gets changed a little bit, is you can't delay the commencement of leave because you haven't gotten the documentation. So if you're asking for documentation and you think that your employee can get that to you in 24 hours and they don't, you can't say, okay, come back or you're fired. That's going to be retaliation. And again, when we talk about the penalties, that's all part of that. So the only way you can really address that under the current statute is you demand that they provide you with documentation. If it doesn't come in what you deem to be a reasonable time, you'll let the employee take the leave, and then afterward, when you get the reasonable documentation, if it doesn't look like it is eligible for ESTA leave, at that point you can take disciplinary action against the employee. You can fire them, suspend them, whatever you might want to do. But you can't prevent them from taking the leave in advance. Otherwise, it's going to be a retaliation claim. And then again, all of this information has to be kept confidential. Don't ask for more than you need to know whether your employee has qualified for ESTA leave. If the more you pry, the more trouble you can get into, and the statute specifically provides that you can't ask any additional questions beyond what you need to know that the ESTA leave is eligible. So let's talk about record keeping. And here, this is another area that is being addressed potentially in some of the revisions. Right now, an employer has to keep records of the hours worked and the earned sick time taken for 3 years. And it has to make those records available to the wage hour division if they show up at your place, usually in response to a complaint, for example, from an employee that says that they weren't given they weren't given sick leave when they asked for it or something like that. But you have to hold that for 3 years. And an employee, in theory, can go all the way back 3 years on this thing if they want to make a claim. And that leads to the enforcement part. And this is another one of the big issues that is being addressed, or hopefully in the revisions that are going through the legislature right now. Right now, an employee can file a complaint with the Wage Hour Division within 3 years of any violation of the Act. And the Wage and Hour Division can award all kinds of damages here. They can award all the earned sick time that was improperly withheld, damages incurred by the complainant, back pay, and reinstatement. So, for example, in that example about retaliation, if you demanded as an employer reasonable documentation of of a leave for more than 3 days, and you felt like you didn't get it and you fired that employee, they can make a claim for retaliation. They can ask for back pay and reinstatement into their position. And the Wage Hour Division is currently authorized to do that. Now, the other side of this, and this is the part that is really being specifically addressed, is that currently an employee can bring their own civil action against an employer if an employer interferes with or retaliates against the employee for the use of ESTA benefits. Now, the translation of that is this act authorizes class actions. So you can see, just like you'll see with employees bringing actions for unpaid wages or unpaid overtime or failure to pay minimum wage, you see those kinds of class actions are filed all the time. Sometimes they are meritorious. Sometimes they're disgruntled employees that are trying to assert some technical violation of the Fair Labor Practices Act or something like that. This statute, as it's currently drafted, authorizes those kinds of class actions. They can also be brought by an individual employee, but that's not where the money is. If we're being honest, the money is in a class action. And there are entire industry groups of attorneys that bring class actions in employment contexts, as you probably all know. And this would be another claim that they could bring. One of the things that is being addressed, or at least considered in the revisions now, is to take this civil action remedy out of the statute, to only allow a complaint to be filed with the Wage Hour Division. Then it's an administrative proceeding. You don't get a lot of the sort of super expense that you might have to incur in a class action, for example. So hopefully that will get through. Even under this current bill statute, though, an employer is subject to a $1,000 administrative fine for failing to provide ESTA benefits, and this is again a sort of critical component of this. An employer is subject to a $100 fine for willfully violating the posting requirements per violation. Usually, when it says per violation on a posting requirement, it means per day. So there is a requirement under the statute that you post the rights that employees have under the ESTA, and you have to do that by February 21st. If you have a subscription to a notice posting company, like a lot of you do, these are the posters that you put in your locker rooms or in your lunchroom that have the minimum wage requirements and all that stuff. And there's lots of different things that are a component of that. Those companies will probably pick this up and add it to their sort of consolidated notice posting, so you can just put it on your wall. If you don't use one of those services, though, then there is a notice form that is on Leo's website, and if you just Google ESTA notice posting and go to Leo's website, there is a link there to a notice that you can print out, and you can just tack it up onto the wall in a conspicuous place, put it with all your other notices, your minimum wage notices and your anti-discrimination notices and all the other things that you have to do. But that is a requirement for now. And again, at $1,000 a day, especially since they have 3 years to bring a claim for non-compliance, you could have 3 years worth of daily $100 fines. It's a lot of money, obviously. So unless something changes in the revisions, make sure you get that poster up by February 21st. Okay, and that's the summary. I think went a little longer than I expected, but I think we have time for questions. I believe, Shane, I'll leave that up to you.
Yeah, and we may go longer than our hour, but this seems to be something everybody's very, very much interested in. So I am going to work to get through these questions. And I'll tell you, Jeff, you may want to have brief answers to these to try to get through all of them. And I may ask you some questions you've already answered. I have been trying to keep track of questions and emails through this, so I haven't been listening to all of it. But let's start with the simple question of, let's say that in 2 weeks they pass a change to this. What is your recommendation for employers if they know that in say 110 days that this is going to go back? What do you recommend for employers?
Yeah, well, the first thing I would say is don't expect this statute to go away. What's going to change are some of the requirements, probably some of the penalties. Those aren't things that affect how you interact with the statute. The way that you interact with the statute is to post the notice on your wall and to maintain records of your employees' work and the accrual of their hours based on that one sick hour per 30 hours work. So always do that. Whatever is going to change, then honestly, we're going to have to wait and see what the changes are. And if they are major, then there's going to have to be some informational sessions, maybe another webinar. I don't know. But in the meantime, my guess is that the things that change are not going to affect how you daily interact with this statute. Keep track of the accruals, post the notices, and comply with the statute for now.
Okay. Um, some of these I may ask the person to come off of mute and give a little more clarification on it. Some of these I'm just going to read them and get through them. Candace said if they're under a union contract right now, my understanding, the new ESTA law will take place upon the new CBA agreement. Is that correct?
Yeah, and I didn't address CBAs because this group doesn't usually deal with them in any large manner. But yes, if you have a CBA right now, then the CBA continues until it expires. There is a little difference with collective bargaining agreements because usually under National Labor Relations Act, once a CBA expires, you continue under the old one until you get a new one or until there's an impasse. That's not the way that this statute works. The way this statute works is as soon as the collective bargaining agreement expires, then the ESTA kicks in and you got to start the accruals right then.
All right. Some of these might be yes and no answers. For a large business, does this include salary employees?
Yes, it absolutely does. And they're presumed to work 40 hours per week.
Okay. Does a large business have to allow any amount of unpaid sick leave like a small business?
No, large businesses only have 72 hours of paid sick leave.
Um, am I understanding the last slide correctly? Can we stop accrual once they reach 72 hours?
Unfortunately, no. The accrual continues to accrue and you have to keep track of it, even if they're at 1,000, 2,000, 3,000 hours under the current statute. Now, again, this is something that's being addressed in the revisions. Hopefully that's going to be changed. But right now, the accrual goes on forever and you have to keep track of it.
Okay. Does existing vacation time count as sick pay?
Vacation time doesn't. So if you have a policy that says we give you X number of vacation days, that doesn't count against sick time. If you have a PTO policy that covers both sick time and vacation day, then it does count. But again, it's got to be for the same purposes as the ESTA, and it's got to be for at least 72 hours.
Okay. If we had 10 employees in 2004 and we have less than 10 in 2005, are we considered large since we had 10 last year?
Once, well, not last year, because the accrual under the statute starts on February 21st. So, but the example that you give for next year is relevant, because if you're small and you become large in 2025, then even if you go down to one employee in 2026, you're still considered large, because it's either in the current year that you qualify, or if you qualified in a prior year, then you're still large for another year.
Okay, I think the next one from Keith was answered about the posters. I posted the link that Jeff referred to on the Leo site. It's posted, well, it was at the bottom of the comments, but I think we've gotten a lot of new ones since I looked. What is the purpose of carryover if they are not allowed to use it and you don't pay it out at termination?
That's a really good question. And that's the question that's being bantered around in the committee hearings right now as they're making a revision. It doesn't seem to have any purpose, but that is what the law says right now.
Lost my spot. Okay, here we go. If an employee has used sick time prior to the beginning of this law accrual period, how does that factor in the fiscal year total used?
You're talking about, is
So
that referring to if they'd used it in, before today in this
prior to the
fiscal year?
beginning of the law, yeah.
Yeah, well, the ESTA requires the accrual to start on February 21st. So the accrual starts then. Um, if you have a PTO policy that is greater than the benefit offered under the ESTA, then I think you need to talk to an attorney, or we need to talk about the specific example, because you may or may not be able to use that PTO to cover that prior sick leave. But again, we'd have to look in a little more detail at what your handbook says and how it was used.
The next question, I think we've addressed it. Does PTO count as sick time? Next comment, tracking nightmare. Yes, welcome to California, I would say.
Yeah,
Will you be sending this recorded webinar? I will send it to your chapter presidents. Your chapter presidents will send it to anyone who registered for this. If somehow you got on here just through like a calendar invite or you didn't register, you can reach out to your chapter president and request the recording. Normally takes like 30 minutes to save to my hard drive after this, and then I will send it out to them immediately. So they'll have it later today. Are high school co-op employees included in ESTA?
it kind of depends, but temporary and part-time employees are. So if you're paying them a wage, regardless of how much time that they are spending at the job, then yes, they do count for purposes of large or small.
All right, next one probably is more of a follow-up, requires a little more conversation, asking if we could provide sample verbiage for incorporating into handbooks. I don't know if that's something that we can work through with you, Jeff, and provide some sample verbiage to our members or not. We can talk offline about that if you want.
Yeah, that's tough to do on a broad basis without seeing the entire handbook involved in a particular employer. But we can talk about that.
Okay. I think you addressed this one. Do employees have to prove their reasons for taking the leave? That was addressed and saying that they have a few days to do that, and if you request it, you could be responsible for the costs of associated with requesting it.
That's right.
Next question is similar. Do employees have to prove doctor's notes? Um,
After 3 days, you can request that. Yes.
can ESTA accumulate more than 72 hours in a calendar year? Example, an employee that works a lot of overtime.
Oh, you can accumulate a lot more than 72 hours. They're not allowed to use more than 72 hours in a 12-month period, but they can accumulate a lot of it. It's unlimited, essentially.
Okay. If we offer 120 hours PTO and they want to take a 3-week vacation, that would not be allowed? Question mark.
Vacation is not an authorized use of ESTA benefit. It might be under your PTO policy, but it would not be under ESTA.
If front loading, do we still need to do accruals through payroll?
I'm not sure what is meant there. You certainly do have to
Joe
account.
Malone, do you want to expand on this? You can take yourself off mute if you're on.
Hi there. Yes, so my question is, if front loading is allowed, then do we still need to show an accrual through payroll? Say we give everybody their 72, do you still have to have that tracking mechanism in place?
Yeah, and that's something where there isn't a lot of good guidance at this point. I think it would be kind of pointless to show the accrual if you've already given them the 72. But now that I think it through, because the accrual is in theory unlimited, the safest route would be to continue to calculate the accrual because, in theory, even though you're front loading 72 hours of sick time, they could accrue 100, 200 hours in a year, and you're going to have that bank accounted for later. So I think you do still have to keep that. And again, this is one of those areas that's being actively looked at in the revisions. So, like, we kind of do need to see what comes out of the revised versions of this bill.
Yes, on Tuesday, actually, I did testify in Lansing to this bill, and speaking with a lot of people there, there's a lot of confusion, as you can tell just by the questions you're getting here
Yeah,
today.
absolutely.
Thank you for your time.
I think this is a simple yes, but I'll ask you, Jeff, does ESTA apply for part-time and seasonal employees?
Yes, it does.
If an employee takes 2 to 3 weeks in a row without notice, can they be terminated?
You can ask after 3 days for reasonable documentation. And again, they're required to provide that within a practicable time. So 3 weeks is probably too long. If you make the request after 3 days and they don't get back to you and it's 3 weeks later, again, it's risky because you don't know. But if a court's going to second guess you on what is a practicable time for the employee, it may depend on the circumstances. If the employee is in a coma in a hospital somewhere, maybe a court would deem that to be practicable to wait 3, 4 weeks, maybe longer before you get the notice. Again, these are one of those things that you would think would be addressed in the statute, but it's not really.
Okay, again, question on the poster. It's in the chat. If you offer 120 hours PTO, employee has used all of that time for the calendar year, then tries to take earned sick time, can it be denied?
Yes, if they, well, again, this is one of those confusing areas, but I would say yes, as long as the as long as you can track the use of that sick time. And if the time that was taken was for an authorized purpose under the ESTA, uh, you can, I believe, you should be able to count that against the ESTA time. They shouldn't be able to double dip on that.
Okay. How do you handle subcontractors, anyone on a 1099 basis?
Well, that's the that's the 400-pound gorilla in the room, right? Because a contractor is not an employee, and a subcontractor is not an employee. So as long as you have legitimately identified your employees and your independent contractors, your employees are the only ones that get the benefit. The risk, of course, is going to be that if you operate with a lot of independent contractors and somebody challenges their status as independent contractors and wants to claim that they are employees, they can file an action for all the things that they usually do in those circumstances, which are benefits, overtime, things like that don't get paid. And this is another claim, which would be ESTA benefits that you didn't provide to them as an independent contractor. But again, as far as the statute goes, if you have a 1099 worker that is a legitimate independent contractor and isn't an employee, they don't get ESTA benefits.
All right. And judging by the fact we've barely had anybody drop off past their time here, I'm going to keep going through these questions for a few minutes as long as Jeff's okay. I
Absolutely.
think I'm getting there. Does the new act replace the current PMLA act that is in place?
Um, I don't know the answer to that right offhand. I'd have to do some some looking into that. So I don't have a good answer for you sitting here today.
Okay. Dave, I've got that noted as a follow-up that we'll look into with Jeff and get it out. Um, Anyone looking for that poster link? I commented at 9:51 a.m. with it if you're looking through the chat trying to find it. Um, is it best to have different banks separating PTO on ESTA?
Yes, yes, it is. It's always going to be best to have that, even if you are using the PTO, because the statute requires you to keep a record of the employees, the hours worked, the time taken. So it's always best to have it. That's the most conservative way. The statute, in theory, allows you to use PTO time for it, but I don't know that I would rely on that if I were the business owner.
Okay. Uh, Earned sick time is only on hours worked, not used vacation or holiday pay. Are they able to accrue on vacation and
No,
holiday pay?
the statute says hours worked. And as far as I'm concerned, I would hold them to that. They say hours worked, that's what that means. So vacation time wouldn't count. Not to say that somebody won't file a claim for that at some point and it'll get worked out in the course, but I would say the likely result is, yeah, it only counts worked hours.
Okay, I think this has been answered, but can we continue with a different set of policies for vacation time and PTO as far as requiring notice and approval?
Well, that's an interesting thing because in theory, most people use PTO as their combination vacation, sick, and all the other leave times that people have. If you separate out your PTO time separately from vacation time, then yeah, you got to keep the vacation time separate and the PTO time separate. And again, if your PTO doesn't match the purposes of the ESTA, then you need to keep the ESTA time also separate from your PTO.
Okay, I think you answered the next one at the beginning, but I was busy emailing a couple people. Out-of-state employees, will this law apply to employees who are not Michigan residents?
It does not. It only applies to employees physically working in Michigan.
Okay. Um, can holiday pay be applied to paid sick leave?
Uh, if you mean, does it count against the 72 hours? Then the answer is no.
Okay.
You remember the big screen we had there with all the purposes for ESTA, and holiday is not one of them.
On the ESTA poster, it states 32 hours of unpaid for sick time for a small business, but is grayed out for a large business. We answered that. So no requirement for a large business to provide unpaid sick time.
Correct.
If we give them 72 hours up front, do we still have to continue with the accrual?
Yeah, and that's the front loading issue that again is part of what's being discussed in the revisions. You do have to keep accounting for the accrual though, even if you front load and pay the 70, grant them the 72 hours up front.
Would jury duty be part of sick time?
It's not considered an ESTA purpose, so jury leave would have to come under some other employee policy.
Next one is about sample verbiage. Again, I will talk to Jeff offline and see if there's something we can do on that front. But again, I think Jeff's early comment about you may need to reach out to an attorney on your own is probably important as well. And I'll drop Jeff's information to help uh, promote him at the bottom here in a minute. So, what is practical time for turning in documentation? I think it was also once requested. What is practicable for turning in the documentation?
It's not defined, and again, that's one of those factually diverse situations. If you've got an employee in a coma, it's going to be a lot longer than somebody who just has a cold.
Is it true a employee can have 3 no call, no show days and still be covered by ESTA, or can you terminate?
And no, that is technically true. They're not required to provide notice until you demand it, and you can't demand it until 3 days.
Okay. Another webinar I watched on this subject stated if you have 120 PTO pot, employees could use ESTA time for vacation, but the employer would want to have it documented with employee's signature. Is that correct?
You can use the PTO time for the vacation. You can't use the ESTA time. Again, the ESTA has a specific set of things that it can be used for, and vacation is not one of them.
Okay. Does the request after 3 days need to be in writing?
The statute doesn't say it has to be in writing, but that's always the best practice.
Okay. I can actually see the bottom of the comments now. So if we have a 120-hour PTO policy, they use most of a vacation. Okay, this has already been answered. Will the recording be emailed to us? Yes, if you registered, you will get an email from your chapter president. Again, if you somehow got on just through somebody else inviting you, sending you the link, or you got a calendar invite, you can reach out to your chapter and request the recording of this. How would you compensate salaried employees who receive a weekly pay every week, regardless if they are there? I think you said they are treated as 40-hour
That's correct.
employees.
They're presumed to work 40 hours unless the position itself is less than that. So, for example, if you have a salaried employee and you have established that their job is 25 hours a week, then it's 25 hours. But if there's nothing like that that establishes less, it's presumed to be 40.
All right. And everybody, I just dropped the last comment in the chat right now is Jeff's, a link to his information. It's got his phone number, his email. So you can follow up with him if you need more information. And then the last question I have right now is, does it apply to HB2 program employees?
Wow. Okay. That's a tough one. Don't have an answer for that right now, but the way the statute does read, it says all full, part-time, temporary employees that physically work in the state of Michigan. So my initial response would be, yeah, it probably does as long as they meet one of those requirements.
Okay, that's it in the chat.
And
Um,
I think there was one that I caught. There was some folks looking to have Jeff elaborate on the doctor's note piece, like whether mileage needs to be paid if you need to request, an employee to get a doctor's note and whatever that would cost could be
Yeah.
charged to the employer. Um,
Yeah, and it
so
does say the way the statute reads is that any cost to the employee of getting the reasonable documentation must be paid by the employer. So, in theory, an employee that makes a claim for mileage, for example, to drive to the doctors to get the note, for example, in theory, that's chargeable. And I would guess probably it would be awarded if it came to a dispute.
and then we just had a couple quick ones come in. 12-month period would be different for each employee, starting with the hire date.
Yeah, and this is again a little bit of a complicated situation because the accrual under the statute starts on February 21st of this year. But you are not required to use a 12-month calendar period for this. You can choose the 12-month period that you want to use. There's all kinds of complications with that, of course, because you start on a certain day. If you started on March 1st, you'd still have accrual through February, through 9 days of February, 8 days of February, whatever it might be, and then you're starting over. But in theory, you don't have to go with a calendar year if there's a business reason that makes more sense not to do that.
Okay, and then last one we'll do BTE. Do you want to come off mute and ask your question?
Sure. He said at the beginning, if you offer a pot of 120 PTO, there's a difference between PTO and vacation time, right? From what you're describing?
Kind of. It depends on how you use your PTO. So if you have PTO that counts for everything, for vacation, for sick, for everything, and you have
Yes.
120 days, you can use that as your baseline for ESTA compliance. The only trick there is you have to allow it for all the purposes that ESTA is allowed for.
So we do have that. We have 120 hours PTO that we use for vacation or for sick time.
Okay.
However, yeah, so if somebody uses 40 hours or say 20 hours for the ESTA,
Yeah, and you need to keep track of what they're using it for. So in other words, if an employee has that 20 hours, that 120 hours, they want to take 20 hours and they say, this is because of domestic violence from from a spouse and I have to relocate my house. That's an ESTA leave. It may not be technically a sick leave under your PTO policy, but it's an ESTA leave, and you need to account for it that way, so that they don't double dip. That you can take it out of your sick leave and comply with ESTA at the same time for those 20 hours.
But only allows then for 48 hours that can be used for vacation.
Well, yeah, what happens with the vacation under that circumstance is irrelevant for ESTA purposes. If they use their full 72 hours for ESTA purposes and your PTO time says they have 120, then they've only got the difference between the 120 and the 72 to use for whatever purpose other than that they want to use it for, whether it's vacation or bereavement leave or anything else.
So basically, you're saying you should not keep a PTO that covers vacation and sick. I mean, that's what I'm getting from this, that it's not combinable. We're offering 120 hours PTO that can be used as vacation or sick time. But if we have to keep track and they are only allowed to use 72 of those hours for ESTA, then it doesn't make sense at all to offer PTO. It should just be vacation and sick time, right? I mean,
well, whether that's right for you or not depends on a lot of things.
I don't see any way around it. How else would you, if PTO is personal time off, vacation or sick time. So if you have to, if 72 of those hours can only be used for ESTA requirements, then I mean, that's the thing that's getting me right now is, I mean, that's what we do too. It's all PTO.
You have to allow 72 hours for ESTA purposes, and if they don't, it's an interesting issue because let's say they take 100 hours in vacation time that they're allowed to take. They've in theory only got 20 left for sick time. What would happen if they asked for 21 hours in sick time after that? That's an open question and that's a risk. You're right. You may have to grant them the 21 hours, I guess, is the answer.
But how many would roll over then? Like, how do you, never mind. I'm just gonna separate them.
That's the easiest way, sure.
Yeah.
And now, again, Jeff, thank you so much. I will end this again by saying this is a free webinar to kind of go over the framework of this. I think some of these, I mean, you guys are going to have to reach out to attorneys of your own and work through these things. You can find Jeff at Foster Swift. I also shared it in the chat there. I shared Eric's email, my email, if you need anything from ABC of Michigan, although I'll tell you, if you reach out to us with a question, I probably got to reach out to Jeff with the question on this one. But we're here to do what we can for you guys. We appreciate everybody logging in, going over the time here. I will get this recording to your chapter presidents as soon as possible. But thanks for joining us. Sorry for the downer on a Friday morning. Enjoy your weekend and a Lions victory and cheering for nobody on Monday in the national championship of college, I guess. So, all right. Have a great one.
Thanks, everyone. Have a great day.